Kosolski, and also our guest professor, Herbert Kronke.
Very welcome to all the attendants to this conference on behalf of the Commercial Department and Faculty of Law, University of Chile. I would like to say a few words in Spanish, if I may. Les recuerdo a todos ustedes que en la parte inferior de la pantalla hay un icono con un mundo que dice interpretación y que pueden pincharlo para quienes quieran utilizar la traducción simultánea. Bien. Mr. Arturo Prado, Minister of the Supreme Court of Justice of Chile, Mr. Herbert Kronke, Emeritus Professor, Heidelberg University, Professor Boris Kosolski, authorities, professor, student, and attendants. During the last 3 days, the School of Law of Universidad de Chile has been the host of Transnational Commercial Law Teacher and Students Conference. We had 5 excellent panels with top-level experts of the discipline with the following topics: the enforcement of secure transactions, the UNCITRAL model, an inter-American model for secure transaction, their influence in domestic jurisdictions, the Cape Town Convention, digital asset and technology, and the last, this morning, secure transaction in general. Now we have the privilege to have Professor Boris Kosolski for the closing conference. Professor Kosolski is the founder and former president of the National Law Center for Inter-American Free Trade, NATLAW, presently renamed as the Kosolski National Law Center, linked to Arizona University, United States of America. He is one of the world's leading experts of international banking and commercial law. He has pioneered the use of standard and best of fiduciary commercial practice as tool for the economic development throughout the world. Boris Kosolski represents the United States of America and the drafting of various treaties and uniform or model laws at the United Nations Commission on International Trade Law, Organization of American States, and the International Chamber of Commerce. Professor Kosolski was the principal drafter of the Uniform Custom and Practices for Documentary Credit, where he introduced the International Standard Banking Practice as the tool for the examination of letter of credit documents, which is followed worldwide. He has a worldwide recognition for his work and contribution for the economic development by means of the modernization of the law of secure transaction in the Americas, Africa, and Asia. He had a key role for drafting the laws for modernization of secure transaction in Costa Rica, Colombia, El Salvador, Guatemala, Honduras, Mexico, Nicaragua, República Dominicana, and Peru. Among his various recognition, we can mention 3 honoris causa degree: Universidad Mayor de Chile, Universidad Antonio Guillermo Urrelo del Perú, Shanghai University for International Business and Economics from China. His most recent book is, fortunately, available in Spanish. La contratación comercial en el derecho comparado, Derecho, Cultura y Desarrollo Económico, editado por Tirán Leblanc in electronic and printed edition 2021. We feel sorry for shortening his impressive biography, but we are very enthusiastic for listening his conference. Please, Professor Kosolski, the floor is all yours.
Thank you very, very much, Professor Caballero, and thank you to Universidad de Chile, to the presence of the Supreme Court Justice, and also my old friend Herbert Kroenke, whom I have not seen since my days in UNIDROIT. I will be very brief in terms of presenting the study, what it does, and then from there on, I'll go to analyze some specific aspects of the importance of legal reasoning in Latin America's economic development. This article discusses how a method of legal reasoning that was employed first by French and Spanish legislators and subsequently by their Latin American successors hindered the economic development of their respective countries. It suggests that significant economic development would be possible if legislators helped enact honest, reasonable, and fair versions of successful market practices in a manner consistent with their nation's or region's development goals. It further maintains that Latin American judges can contribute to the attainment of such goals by adopting a method of reasoning that differs from their present method by being more factual, more contextual, and more reasonable. And I'll go into the meaning of these terms as I proceed by discussing the topics of this presentation. The proposed method requires that in disputes caused by disabling effects of obsolete statutory or case law, as was the case in this study in France and in Spain, and in dealing with promising new customs and practice in the absence of corrective statutory or administrative law, the judge should act as a quasi-legislator. And in that capacity, he should consider not only the pivotal facts of the dispute and the applicable law, but also his nation's socioeconomic conditions and economic development goals. Then, by reasonably balancing the equities involved, his decision should enable what Justice Oliver Wendell Holmes Jr. of the Supreme Court of the United States referred to as the creation of the precedents, or as he called them, prophecies of what courts will decide in future cases with similar facts and legal issues. He should also heed the advice of the distinguished Mexican legal philosopher Eduardo Garcia Maínez, who urged judges to fill the normative gaps in the existing laws with equitable judicial individual norms. In adding this updating and corrective statutory and judicial work, the judge's methods of reasoning should be guided by a definition that we will discuss in greater detail again, but at this point, it should be possessive of a minimum of honesty, reasonableness, and fairness, as is present in a pioneering fashion in the German civil and commercial codes and in the UCC of the United States. So we asked the question, how could we illustrate the role of code provisions, the negative role of code provisions, that is to say, in the French and Spanish codes, civil and commercial codes, on their effect for the economic development, first of France and Spain, and then Latin America. One contractual promise of the French CC, or I will refer to it CC, it's the Code Civil, illustrates the reasons and consequences of the legislative failure to adopt reasonable commercial practices. It is Article 1589 of the French CC, set forth with the following rule, which remained in effect until its abrogation in 2016. The promise of a sale is deemed a sale only when both parties reciprocally agree on the thing sold and the price. In other words, the declaration of contractual intent of Article 1589 of the French CC was unenforceable unless it became part of a subsequent enforceable contract. As we will see in the part that has to do with contemporary decisions by courts at the end of this presentation, you will find a Mexican case that says exactly what this provision says. And then it became clear that according to section 130 of the German Civil Code of the Bürgerliches Gesetzbuch, hereafter BGB, set forth a sharply different rule. Listen to it. A declaration of contractual intent that is made to another party becomes effective if made in his absence at the point that it reaches the other party. That is to say, you don't have to have an intermediate contract in order to be able to enforce a firm promise issued by one of the parties. Now, assume that you're doing business in the European Union country and you receive a promise of a sale of a truck that you need urgently from a French truck dealer, and that this promise is governed by the above Article 1589, which requires the signing of a contract of sale before an earlier promise to sell the truck could be enforceable. Contrast such a promise to one issued by the German truck dealer, governed by the above provision, section 130 of the BGB. Whose promise or declaration of intent would you rely on and get your truck as quickly as you need it, which is very quickly? Another illustration of the problems with these codes: assume that you're an issuer or recipient of promises limited to future transactions that involve the future purpose sale of equity securities, of commodity futures that are traded daily in the billions of US dollars throughout the financial world, in more than 100 exchanges or bourses in 4 continents, and which requires only sending a buy or a sell electronic instruction to the intermediary. Could your brokerage or securities or commodities business be successful if the promises to buy or sell future goods and services were governed by Article 1589 of France? It is true that the present market for future promises and transactions did not exist in 19th century France, and even less in Robert Potier's 18th century writings. The provider of many of the definitions, classifications, and contractual and promise restrictions adopted by the French CC. Yet Potier had only observed the borrowing practices of, Potier only observed the practices of French businesses, including those of Parisian seamstresses, who earned their living from issuing and receiving promises of future performances, he would have learned that in their businesses, they relied on something called book debts. In this method, the book debtor promised to pay his or her on future installments by merely acknowledging that debt to the creditor's promise with a merely handwriting entry in book debts. Yet before you assume that the serious uncertainty of French CC rules affected only unilateral promises of future performances and not concluding contracts or concluded contracts, if you turn to 1131 of the French CC, you'll see that according to this article, a contractual obligation without a cause or with a false or unlawful cause illicite, had no effect. What did French courts then understand by an illicit cause? Imagine, for example, a French decision of 1976, in which the illicit cause was the fact that it was generally immoral by the French population to do certain things. So the definition was immorality of conduct. This could be, for example, in the case that I referred to, that 1976 decision. This is the case in which somebody who was a married man entered into an adulterous relationship with a mistress and later on bought an insurance policy that named her as the beneficiary. The Cour de Cassation in France agreed and held that such a designation was affected by nullity because of the immoral cause. Yet, what if the immoral cause was something that did not exist at the time that the obligation was created, but came about later? That same year, actually, I was teaching in Aix-en-Provence, and I discussed with the students the following situation. One of the students was a banking lawyer for a bank in Marseille, and then this bank had given a loan to a dancing academy. Well, this dancing academy apparently 5 years later or so had become a brothel. Yet the bank, not knowing that this dancing academy was a brothel, tried to bring an action to collect on its loan when it was a dancing school. Now here you have a cause that was a priori, which a priori was perfectly valid, but in the course of time, it became something that was against public and moral policies in France. What do you do in that case? How could you anticipate it? I asked, that same year, I visited the University of Salamanca in Spain, and I asked, it was for a conference for a set of judges, and my question to them was, what kind of an application do you have of the concept of causa? Is it causa as it was a priori, or is it causa as it comes about later? 10 of them raised their hands, 10 of or 13, and they said it came about afterwards. It was a posteriori. Now, how can somebody in their right mind think that this could have been previsible and avoided? Then I sent a letter. I had also been at the university at LSU and had shared the Talker lectures with Dean Carbonnier of the French Law School. And I asked him, or better still, I sent him a note that said the following: despite the presence of many national and international contemporary commercial contract practices that are indispensable components of the commerce among the world's most advanced economic nations, including members of the European Union, these practices are still available in countries governed by French and civil codes. The state of affairs is detrimental to the growth of France and Spain's economies, as well as to the economies of developing nations in Latin America. I submit, Dean Carbonnier, that the time has come to replace these obsolete 18th century codified rules. That was a long time ago. He replied very gently, and he said that he was optimistic that very quickly it would happen. It took 13 more years, and finally in 2016, the president of the French Republic issued Ordinance 2016, among which were the following provisions. An offer may not be withdrawn before the expiry of any period fixed by the offeror, or if no such period had been fixed, before the end of a reasonable period. Reasonable period. I emphasize that word because we'll come back to it again and again. And again, Article 1117, an offer lapses on the expiry of the period fixed by the offeror if no period is fixed at the end of a reasonable period. Other interesting provisions were the elimination of causa. A contract is supposed to be interpreted in accordance with the common intention of the parties rather than stopping of the literal meaning, rather than stopping at the literal meaning of the terms. Where the intention cannot be discerned, it will be interpreted in accordance with a reasonable person. And then the elimination of causa came about by merely saying that all that you have to use is the contents of the contract. Causa was no longer either a priori or posteriori. Now, why did these problems came about? I suggest by the title of the book that Professor Caballero has been kind enough to read to you, i.e., Comparative Commercial Contracts, Law, Culture, and Economic Development, that culture plays a very important role in these rules. According to Theodore Mommsen, the Swiss author of the History of Rome, the Rome of Cato the Censor, Caton in Spanish, was not very partial to merchants and their constant preoccupation with their profits. They really preferred, said Cato, the farmer, who also was a soldier. The merchant was not truly a good Frenchman. He was too preoccupied with his profits. Then you have a similar version of the merchant in a publication by an English consul in Baramel in Spain. It was his Lex Mercatoria Rediviva, in which he says, the Spaniards have very considerable ports equally well situated for commerce, where large concerns are transacted, though principally by foreigners, as the Spaniards in general consider traffic to be a mean employ and consequently a derogation from the gentility that almost all of them affect to. So in the case of France, however, it was complicated because the French bourgeoisie, which was the strongest social class in the 18th century, made a living by lending an interest to particularly the agricultural population of France. That is to say, the population of France that lived off of the exploiting of the soil had to depend upon the credits given to them by the bourgeois, and the bourgeois had certain practices to ensure their collections. They relied on, in a public deed, escritura pública, notarial deed, in which later on a great commentator of commercial law in France, Professor Georges Ripert, referred to these particular notarial deeds or escrituras públicas as effectuating not only the law of the parties, which was the definition given by the civil code itself to contracts, but it says it's the justice of the parties, contractual justice contractuelle. What is the meaning of justice contractuelle? It was that when you read and interpret an escritura pública or a public deed, you cannot go into the common intention. You don't go into what was the usage of trade, the customs of the trade. All that you need to do is what's stated in that document, and that's it. That's the interpretation that you give to those, especially the most important, economically important contracts. This is a particularly negative attitude derived from a culture that does not like commerce, because as we'll see, the interpretation of contracts, which would have been, say, in the case of the German civil and commercial codes, and in the case of the UCC, largely done by looking not only at what the parties say, but their course of dealing, that is to say, what have they done before in their previous transactions, or their actual intent, that is to say, as expressed in extrinsic documents, that is not taken into account. So definitely then the attitude towards commerce as a cultural component was very important in France and Spain. What was also very important was the attitude toward usury, as we've just seen, in France and Spain. As we know, Pope Urban III had declared that no interest was really in a decretal of 1188. It said that it's not acceptable to charge interest for money, following St. Thomas Aquinas's warning in the Summa Theologica, and following Aristotle's essences. By definition, by an Aristotelian definition, you mean the essence of things. Aristotle defined by identifying that which is permanent and universal in a thing, and each thing had its essence. In the case of money, the essence of money, according to Aristotle, was that it was an arid or sterile commodity. In other words, it does not create more money, as a Latin saying had it, pecunia non parit pecunia. Money does not beget money. Centuries later, an English utilitarian thinker, Jeremy Bentham, said that Aristotle must not have had good glasses in his day to discover that money did have reproductive organs after all. Okay, so the direct taking of his usury interest was locked out, and very shortly we will see how this had a very major effect upon the development of the law of negotiable instruments, not only in Europe, but throughout the rest of the world. And it was the contrast between the negotiable instrument, which was not a negotiable instrument, as conceived in France and Spain, as contrasted with the negotiable instrument as conceived first in Germany and then first in Germany and then in England. The negotiable instrument that was conceived in France was the lettre de change, la letra de cambio in Spanish, the bill of exchange. The bill of exchange, as stated by its name, was an agreement that was entered into for the purchase and sale of currency, exchange, foreign exchange. It was not for a loan, because God forbid, if it is a loan, it is immediately suspected as being usurious. So in that case, what you have to do is enter into a contract in which you show that you have paid money, but just as a commission for the payment of an exchange instead of at interest for a loan of money. That created the notion of the bill of exchange as basically a contractual instrument in which all of the underlying transaction considerations, equities, and defenses were interposed, as opposed to an instrument in which what you had was like money. That is to say, what gives money its moneyness is the fact that it is an unconditional promise to pay. Because if you were to condition it, it would not be very liquid. People would doubt what is that's behind it that would basically allow you to say, no, I don't owe it, because this is a result of this or that type of an obligation. So a study by an English barrister, his name is Henry Dietrich Jenkin, of negotiable instruments law and practice, in particularly in England and in the rest of the continent, points to the very negative effect that that definition of the contract of exchange, which was a contract, it was not a firm promise issued by either the emitter, the issuer of the bill of exchange, or the acceptor on the other side. This was practically a useless instrument for the purposes of developing a credit market. Consequently, at the end of the 18th century, you had a market in which it's a European market in which basically Germany and England were the bankers of the rest of Europe, and also in many instances of the rest of the commercial world. Then the effect that this had upon the markets was that there was no developed market for, say, government bonds that could finance public housing in any of these countries, as there was also no access to commercial credit at the lowest possible levels, including, as I indicated earlier, the case of these seamstresses who had to be charged very, very little, if any, interest and which is reflected, incidentally, in the decisions of the first commercial court to have been created in France, where you constantly have this problem of, is it really a usurious type of a transaction or not? This fear of usury is one that created, in effect, the lack of a development of a banking industry in major countries, except for, as I indicated, Germany, England, the Netherlands. The rest were basically very, very lacking in credit until the beginning of the 20th century in both France and Spain. So what are the preliminary conclusions? The preliminary conclusions are that when you have attitudes such as described in that provision about the future sales or future promises, and you have a definition of that type of a promise as issued by Potier, which called it a policitation, and therefore unenforceable. And then when you have a notion such as justice contractuelle for public deeds, there is no way you could develop a commercial law that is consistent with present practices, true practices, as opposed to the fake practices that are supposed to be used to make sure that nobody confuses you with a usurer or moneylender. Then let's look back to the roots of this attitude. Is this attitude towards contract? Is this attitude towards usury attributable to Roman law? The answer is obviously not. It was not, because it only came about much later. But in classical Roman law, you have already two different ways of thinking. The logic of classical Roman law is apparent in a way of relying on observation of everyday practices. When the Romans, for example, characterized the sale agreement as a consensual contract, they were observing market practices. When they were characterizing other contracts as synallagmatic or requiring immediate exchanges, again, they were characterizing it. Sometimes the characterization was more sharp than in others. Because, for example, when you look at the characterization of contracts by certain jurists, they would develop what could be described as a geometric type of logic. This is a logic that allows you to measure the quantum, the quality of rights by certain characteristics. So the Romans, some of the Romans, for example, when talking about the duties of a borrower in a commodatum type of a contract or personal use type of things, made distinctions between whether the borrower of the thing actually used it for his own purpose when he had it and when he was just a depositary for the other party. So you measure whether in one case that person that uses it for his own purpose owes more to the other party, has a greater duty of caring of that object than the other one. So the duty of care in many contracts, because of that observation, there is somebody who's using it also not for keeping it, that is to say, not a bailment, as you would call it in English law, proper, but just as a favor to somebody else, then that person doesn't have as many duties to the other one as one that profits from having that thing by himself. That was the geometric logic, and it was truly an advance on what happened before. But the most important advance was the one provided by a type of logic that was described by one of the greatest historians, perhaps legal historians up until our day, and that was a professor at Heidelberg, the same university where Professor Kroenke, I found out, was teaching, Professor Levin Goldschmidt, in his Universalgeschichte des Handelsrechts, or the general history of the commercial law. He points to a character, to a person in Roman law that the Romans referred to as a bonus vir, an honest, decent, reasonable merchant, an honest vir. And one of the jurists, Ulpian, describes how one resorts to that judgment of that honest bonus vir. He describes it by, it's a case in which a slave owner sold his slave under the condition that the slave render immediate accounts to the slave owner. And then a year goes by, the slave didn't do that, yet the slave owner had not complained at all to the buyer of the goods, the goods in this case is the slave, and for all that year, and suddenly he says, I want to get my slave back. I rescind the sale a year later because he didn't give me any kind of report that he was supposed to give me. In Roman laws, slaves are very frequently the managers of the estates of their owners. So Ulpian looks at it and he says, this doesn't make any sense. How could you in the same contract say, I sell you, and on the other hand say, well, I sell you, but only according to my will. That's what counts. And my will is now a year later. That is unreasonable. And at that point, it became clear that this type of reasoning that Ulpian, among many others, was recommending to the interpreters of contracts under Roman law was a much more important notion than just distinguishing based upon what the observant said about the fact itself, or doing classifications as contracts to do or not to do, or contracts to give as opposed to do, etc., as we'll say shortly. And in his universal history, Goldschmidt refers to this particular bonus vir as the ethical juristic genius of classical antiquity, and especially that of Roman jurists, created an archetype valid for all time, an honest, reasonable man of affairs, a bonus vir, listen to this now, equally distant from brutal egoism and from otherworldly altruism. In other words, this was a person that shared in what a great sociobiologist, Professor E.O. Wilson from Harvard University, described as the nature of man as opposed to the nature of beasts or animals that were close to him in the evolutionary scale. Man was definitely a combination of altruism and egotism. And the best merchant is he who, according to the rules of reasonableness that Goldschmidt, based on the bonus vir, can discern between what to do between one and the other. So this type of reasoning is a reasoning that, yes, it takes into account very seriously the facts of the transaction, but also the context of the transaction. Who are the parties? What did they want? What are the consequences of a rule in terms of how many people might be able to profit from it and who not? All of these elements are the ones that created what a great Spanish legal historian, Luis Requesens, called la lógica de lo razonable, the logic of the reasonable. That is to say, taking into account not only a very clear understanding of the facts, which is very important, or taking into account what was done before, previous experiences, but also all the consequences of one's actions. This is a logic that was adopted first by the German Civil and Commercial Code and was adopted later by the UCC. If you go through the German Civil and Commercial Code, you'll find constant references to concepts such as good faith, to concepts that you have a bonus vir in whom the French Commercial Code goes an ordentlicher Kaufmann, that is to say, a very respected buyer and seller of goods, etc. So this is the kind of legacy that the Roman law should have given us, instead of the legacy of just classifications, including some classifications that during the Middle Ages gave rise to rules that the French Civil Code adopted and retained to this day, obligations to give and obligations to do. And then you say to yourself, well, wait a second, isn't giving something an obligation also to do? Yes, but what depended in that in Roman law was what kind of a remedy contract law would give you. If you are in obligation to do, then the Romans said that's very much like in sporting, a duty to do and force you to do that manu militare is very much like slavery. So that should not be, in that case of a contract, the type of an obligation. It should be something like damages. So in a breach of contract for obligations to give, you get, to do, you get damages. That's a general rule, said Paulus, a Roman jurist. On the other hand, you have a medieval jurist like Modestinus who comes up with the following reason why there should be, in the case of obligations to give, not damages, no, that what it should be is you enforce it manu militare. And he says, imagine that somebody wanted to buy some bread and he was very hungry. He was starving to death. Are you at that point going to say, give him damages? No, you have to force it. You have to bring in the army, if necessary, and force him to give him the bread. But then I would ask Modestinus, now what happened if you get the damages? You have the money to buy all sorts of bread and find it a lot easier. Well, this is the type of classification that is not based upon the notion of what is reasonable. It is based on imperfect observations, such as that of money and usury. The point at which we are right now is to see how is that logic used by Potier when creating all these classifications and in this French Civil Code. Why did he do it? Well, he didn't do it because he thought of himself, but he was a great admirer of a natural lawyer, Hugo Grotius. And Hugo Grotius, he arrived at the conclusion that there are certain forces that are immanent in nature. And those are the ones that the law of nature should really pay attention to. And in the case of immanence of nature, Grotius says, when it comes to contract, an immanent force is what he called the voluntariness, the will as part of the contractual obligation. Namely, unless you have will, that is to say, the parties have exercised their will, you don't have a valid contract. Okay, but he was looking at a contract between two parties, right? How about a formal promise, like in that promise to do something in the future? Oh, no. That requires that there be a will of a contract. So you cannot enter into a contract. You cannot have, for example, an option to sell something in the future. Because why? You have to have an immediate contract. You cannot wait all this time to say to the other party, now you promised it in the past, now give it to me. It's got to be a contract right away. Now, just to give you an illustration of the impact that this particular problem has in this definition, I'll tell you that we had a meeting in Mexico City with the construction industry. Why was it that many cities in Mexico were not having construction needed for their own businesses, for their apartments and public housing? Well, because many of the people that wanted to buy the land wanted to know that the land was okay for it, that there was electricity, there was water, etc. Well, you couldn't, based upon this notion, this Potier notion that this is a policitación, that this is a promise that unless it becomes a final contract before a notary public, because it's a significant amount of money, you cannot do it. Well, the Association of Brokers for the city of Mexico City estimated that for the last 10 years, at least $4 billion worth of transactions had been lost because they could not go into an escrow for options for future agreements, etc. The same problem, you have it with also other classifications derived from Roman law. For example, from this logic, either the logic of these classifications based upon Aristotelian notions of what is the permanent universal truth without looking at the real reality of money, but also the logic of the law of nature that Grotius popularized in his Law of Nations. So these prime brokers from Mexico City said that if Mexican law would have allowed all these promises in the future, i.e. options to buy, options to sell, etc., they had already a calculation of the loss programs. Now, imagine other countries, let's say that Chile had a rule in its civil code that says that a pledge agreement is only for tangible goods, as many of the Roman law influenced, pre-classical law influenced in many countries as a result of the French civil code. Then Chile would not have had I recently, a few years ago, I checked with some friends in Chile, professors and former students, and they told me about the fact that 14% of Chile's economy today depends upon the loan of money based factoring, the contract of factoring, whose principal pledge is that of the accounts receivable. But if that account receivable is intangible, it is a note in a bank, a note in a balance sheet, or even worse than that, an electronic message. This is not acceptable. So the whole business of factoring could not exist because of a classification of things based upon an Aristotelian incomplete version of reality. So the logic of the reasonable then is one that has proven itself in these countries, as I indicated, the United States, but before that, the United States was lucky that Professor Carl Llewellyn, the author of the Commercial Code, had studied in Germany and became familiar with the Civil Code of Germany and the German Commercial Code. And he said, oh, well, that's why this is a very, very good approach, because it takes into account not what I think or somebody else thinks, but what the practice of a transaction, particularly if it is an honest, if it is a reasonable, if it is an equitable transaction, does for the parties. And that appears in the definition of good faith, both in the UCC and in German commercial law. Now, the last part of the talk is the examination of a few decisions that illustrate what I've just told you. And the first one is a decision, a 1955 decision by Supreme Court of Mexico, in which the court said plainly, no, the parties here had signed something which is called an option or something like that. That's not enforceable. That is not an enforceable promise, because it's only a preparatory promise, one of the effects. So there are, again, no options, very bad for the market. What about Viteri, another decision that I discussed? This decision is one in which an engineer, a petroleum engineer, agrees with the owners of a Mexican oil well that if he could develop the oil well so that it is productive, many people had tried to make it productive, they failed. He says, if I do it, would you give me 50% of the royalties? They agreed to that. He makes it productive after very hard work, investing his own, not only time, but also his money. Unfortunately, engineer Viteri dies, and the heirs, the owners of the land, say to the heirs of Viteri, here, what we owe you is his salary for the last 2 months, but how about this royalty, 50%? No, I was terribly sorry, but you should have done a better job writing your contract, because this, what you have in this situation, is a personal type of a contract. The classification of contracts between personal and non-personal, it's a personal contract. This is a classification that tells you that since it's a personal contract, when that person dies, that then he disappears because it's based upon the person who was alive. Now, wait a second. How much money did he actually give you? How were you enriched by what he did? No, terribly sorry. But we have another classification in terms of our court actions. And it says that justice must be prayed justice, justicia rogada. You cannot say that you want something and then you change your mind, say, now I want a different cause of action. You brought an action for breach of contract based upon a personal contract. Now, terribly sorry, you should have done something else. So the end result is what? Terrible injustice. And not only that, it discourages people like Ingeniero Viteri to enter into agreements, joint venture agreements that are very, very helpful to society. And God knows how much money was lost as a result of that. Then the third case, in contrast, is a German decision of 1935. It appears in a book by Rudolf Schlesinger, one of the great US comparative lawyers. And these are very briefly the facts in that case. The defendant in this case had offered to prove to the plaintiff, and he had been active in stock corporations as a professional opposition person. That is to say, he said to a bunch of people, I'll make you a lot of money by joining corporations and opposing all sorts of corporate decision making. And I'll give some reasons, but unless they buy us out, then I'll keep on opposing that the corporation accept this type of decision making. So the court said, the German court said, a shareholder has the right to track those resolutions of the corporation which are inconsistent, according to him, with the law. But as he does that, he has to have, quote, a duty of loyalty and faithfulness, which the shareholder owes the corporation in which he's a shareholder, a duty that permeates all the rules of corporate law. It becomes abusive and unenforceable. Section 226 of the BGB, beyond that confines of provision, says that the same principle must apply. However, the exercise of a right constitutes a gross violation of the maxim that dominates the nation's entire field of private law, the maximum of bona fides, of good credit. Section 226 of the BGB says the exercise of a right is improper if it cannot have any purpose other than that harming another party. Again, reasonableness. Finally, I'd like to, quickly, two American cases. The case of fridge element, in which the question was, what is a chicken? People were arguing whether a chicken is X or Y or Z, depending upon the type of chicken, whether it's to fry or to broil or to eat differently. The type of chicken, it costs different. The prices are very different. So the judge asked himself, what is a chicken? Then the buyer is saying, here, we have all these interpretations that I've gotten from all these manuals, and all these interpretations show that I'm right. The judge looks at it and he says, but you're right, and imposing a price which the seller, under this type of a price, he's shown that he's losing money with each chicken. Yes, Your Honor, too bad, but that's what he'd agreed to. To which Judge Friendly says, terribly sorry, but you got to be reasonable. You have to take the other party also into consideration. Every party, you and the others, is entitled to a profit. Your interpretation is unreasonable, therefore I cannot grant it. Same thing, but even to a stronger degree, a decision by Justice Cardozo in a case in which this is like in the Viteri case with the engineer. This is somebody who's helped out an owner of a building in New York to make the building, which had been totally worthless, into a very profitable building. The neighbor looks at this and says to that person who fixed the building for the former owner, he said, listen, how much did that guy give you by way of an interest or percentage X? He says, I'll double it. You do the work for me and only for me now. Now, the first entruster of money to this particular engineer had actually entrusted everything he had to that transaction, including the discretion to do things like he wants to. And now he didn't tell anything to his first customer, the engineer of the second one. He didn't say anything. He just did the business with the new one. This, according to Cardozo, was a violation of a very important principle. The principle that Cardozo, as the German court had categorized as uberrima fides, the maximum state of entrustment. And this is the rule. It applies to what Cardozo refers to a fiduciary transaction. If there is a fiduciary transaction in which I entrust you with my savings and you take the discretion to do it, and you do very well, and then you ignore me in what I did for you, that is to say, I create your ability to shine in this market, you have the duty at least to consult me and saying, would you like to participate in this other one? Because that is a duty that comes from acting as a fiduciary, as an elder brother, and not just as the trodden marketplace of wolf eating the wolf, Hobbesian man. In those circumstances, said then Cardozo, I would require that your duties be that of a fiduciary, and that is uberrima fides. Finally, a Costa Rican case. This is a very important decision because it was a case that made Costa Rica a much more solvent and developed nation. It was a decision by Justice Fernando Bodrit, who basically said that when you record a transaction, in this case it was a trademark, you have to follow the principle of good faith that these courts that I have attributed to before followed. And then he said there are two systems. The attributive system assumes that the filer either makes or sells or both the same filer's pre-existing products. In contrast, and this is the German system that he called as the attributive filing system. The contrast is a declarative system that requires mere declaration is enough as a filer to give you the right if you did it first. In this case, what had happened was that the trademark had been owned originally for more than 40 years by an English company, and everybody knew this company as the one that provided this so-called hilo marco azul, marca azul, a blue blueprint. And then this guy comes in and he forges this new marca azul and says, the first registration was not complete, it was missing and this and that, and consequently I take it over. And the market only knows now the second one who didn't do anything to earn that trademark. The decision at the end by Justice Bodrit, Chief Justice Bodrit, basically reinstated the meaning of good faith in contracting in Costa Rica. And shortly, a few years later, I had been teaching in Costa Rica for a while. And then a few years later, while I was at the University of Arizona already, I got a call from a lawyer for a company named Intel that does all sorts of very good electronic things. Intel was looking around in Latin America, particularly in Central America, to create a place to employ more than 7,000 people. He asked me, is it true that Costa Rican courts are much more equitable, fair, and good faith minded than other courts that you know? And I said, yes, that is the case. I gave him the case. He read it, and as a result of that, the decision was made by the company, by Intel, to go to Costa Rica, set up Costa Rica as its place of business. And a couple of years later, they had 7,000 employees working in Costa Rica. So I conclude that commerce, as perceived by a long and distinguished list of social and biological scientists, is a cooperative both egotistic and altruistic endeavor. But from a normative legal standpoint, the contrasting economic development experience between a method of reasoning that is both amoral and formally logical, and a method of reasoning that is moral, reasonable, and fair could not be starker. The reason for their disparity is simple. Neither widespread commerce nor significant economic development can prosper when it is a distrustful environment. And as shown by Costa Rica's, Germany's, Great Britain's, and the US experience, trust is only earned by honest, reasonable, and fair commercial practices and by a law that reflects them. Thank you very much.
Many thanks, Professor Kosolczyk, for your interesting and also very suggesting presentation today, where you argue about opposed logics of the legal systems and the way in which particularly these affect the Latin America's economic development. Before to share with you the question from the TCL's participants and the public, if any, I would like to link your presentation up with our 3 days conference about transnational commercial law, namely the body of law governs international commercial transaction. So, in your opinion, Professor Kosolczyk, how transnational commercial law could help to prepare the ground for overcoming the different, even contradictory logics of legal reasoning among different legal systems, as you clearly have described in your presentation?
Well, one of the ways of doing it starts out at the law school. I believe that the courses on commercial transactions should be much more factually oriented than they are now. Remember that one of the means of being reasonable is to really understand the facts. And if you take a fact like in the case of the engineer Viteri in Mexico, it does not help that the way in which the Mexican compilers of what they called jurisprudencia definida, defined case law, only cited what the court's words are at the end. This is un contrato personal, this is only a personal contract, and consequently the defendant, the plaintiff did not make its case or whatever. The more the students are familiarized with the facts of each transactions, and then why are those facts the facts? Where do they come from? What influenced those facts? Culture? If so, what is it? The culture? Is it a culture of commerce, in favor of commerce, or is it a culture that says no, all the merchants are just a bunch of exploiters, shysters, etc., and consequently commerce has no place in our society? So starting out from a much more factual, contextual analysis of what the transaction in point is, then the student will be much better equipped to be able to analyze, really, is it reasonable what is being suggested here? Because his amount, his understanding of the world commercial, will be very definitely helped by being exposed to more facts and to more contextual type of information, that is to say, culture, as well as previous existing practices in society, existing customs and usages, etc. This, you have a very sharp contrast in Latin America, for example, between, still to this day, the Mexican Commercial Code does not list commercial custom as a source. In contrast, Colombia, Article 3 of their Commercial Code says that it is at the same level. Custom is at the same level as statutory law. Okay, so depending upon what importance you ascribe to commercial custom and why it got there, then the better the law could be. If I, for example, when I was drafting UCP 500, whose main problem was how do we stop this huge amount of litigation concerning letters of credit? In the United States, it's gone up 50, 60% each year. And why? And then if you start looking at the practices and you see that there is a practice that abuses, like in that German case, the doctrine of strict compliance and letter of credit law that says that only a document that is strictly in accordance with the terms and conditions of the credit. That is to say, strictly means, oh, if it's missing an I, it's missing a period, it's missing a bad last name, that is grounds for saying by the bank, I'm not going to pay on this, because this is not strictly in compliance. If you are trying to make it a much more honest, fair, reasonable, and trusted transaction, then you have to really know what the practices are. And then at that point, the methodology tells you, try to find what practitioner is the one who's the most followed, obeyed, and respected by his peers, i.e. a bonus vir. Who's the bonus vir in this profession? And you ask that bonus vir, what would you do? Then you can come up with a much better rule. So education has a lot to do, but education has to take into consideration not merely the strict text of the law or the strict interpretation of the law or whatever, but as many other sources as possible. It's got to be more interdisciplinary. It would help many students to understand more anthropology of law, what anthropology of law could teach us, economics, what economics could teach us, etc. So opening up the teaching of commercial law to these other disciplines, particularly having in mind the need to arrive at honest, fair, and equitable rules, or fair and reasonable rules, that to me is the way to really enrich not only the education, but have a much more trustworthy legal system.
Many thanks for your answer, Professor Krosowski. We didn't receive, as far as I know, more questions. Maybe Professor Herbert Conke would like to take the floor for a little comment, if you want.
There's one question.
Very, very briefly, thank you very much for this firework. It was a lecture my students and probably all students of all the participants of the teachers' meeting would have loved to attend. And the subject matter you just pointed to indeed is fertile ground for educating our students. I remember when we last met, which was in Mexico City, there was Roy Good, Jorge Sanchez Cordero, a couple of US colleagues. And as the evening went on and the tequilas were more and more quickly empty, we talked more and more about UCP. And indeed, when I taught transnational commercial law, the Cape Town Convention, for example, or the Vienna Sales Convention, those were parts of the course where the teacher spoke and the students made notes. But the bank undertaking, i.e. the background to the UCP in its various editions and so forth, the international bank undertakings, that is what fires up the transnational commercial law teachers meeting, because indeed there what the students need are facts, facts and facts. And I have still receive 10 years later notes from former students, from former participants of the course, who are now working in the banking industry in Australia or in various countries, who come up with questions and assure me that the way we discuss the international bank payment undertakings, i.e. the UCP, was something that opened their eyes to the relationship between reality, commercial transactions, and the law, which in very many other areas is abstract. So a tribute to one of the cornerstones of your lifetime work, which others certainly shared, that taught the course as Roy Good and your good self. Thank you very much for this wonderful memory which you provided through your lecture. I couldn't have a happier introduction to my afternoon than that. Thank you very much, Professor Gutowczyk.
Thank you. Thank you so much.
We have a last question from Professor Ana Veneciano. Please, Ana, take the floor. We cannot hear you, Ana.
Thank you very much. Now you can hear me. And I wish, first of all, to express my appreciation of this masterful lecture. I too had the pleasure of receiving so many inputs. And this is important for Latin America, but it's important for so many other legal systems to look at what the facts are and to be able to appreciate the importance of introducing transnational concepts and transnational commercial law at the level of university studies, which is not always the case. So thank you very much. My question is whether, when you look at the development of new technologies, which is now considered to be so central and important, would you say that their impact on commercial transactions will be a globalizing factor, introducing more harmonization of legal systems in view of the fact that the technology is global in nature? Or would you think that there is more of a risk of further differentiation and different approaches to how to deal with the technology? I'm saying this because we are working at UNIDROIT on projects to harmonize even the way of thinking about technology and the law. And so I was wondering what would be your opinion on this?
Yes, my opinion is that there is a very strong link between technology and the ability to harmonize what you describe as your present work in international trade. One of the present projects of the NAPLAW is the creation of an international electronic warehouse receipt, which UNIDROIT is also looking at. I understand my colleague Marek Dubowicz is working on that project. Well, Why did this project come about, Professor Veneziano? It came about because it became very clear that there was a lot of distrust, particularly in the European, Asian, and even Northern Western Hemisphere countries for the agricultural products that were being bought from Latin American countries. There was a lot of distrust because the description of the quantity or the quality of the products was insufficient, if not very frequently not true. In the case of Mexico alone, the warehouse receipts that were issued by Mexican warehouses were subject to more than an average of 500 frauds a year. So if a country wants to improve its economic being, its status, and in the case of Central American countries, as we all know, even more so because of the horrible problems with violence and robberies and penury and poverty and everything else like that. If you want to be exporting your products, then you will depend upon a legal instrument that will provide that type of certainty. And in order to provide that type of certainty, the electronic warehouse receipt has succeeded. The US electronic version of the warehouse receipt has succeeded because it managed to eliminate the doubt about the fraudulent nature of the transaction. How did it do that? By using system providers, as they call them. That is to say, electronic systems that record everything that happens to a cotton shipment or a vegetable shipment from the moment it is collected to the moment it is placed in a warehouse. How does it do that? Because there is an internet, something called an Internet of Things, that uses sensors, electronic sensors, to determine whether what has been in the ground as a product, or in the case of South African mines, diamonds that are going to be bought in, it actually detects both the quantity and the quality. And that detection becomes part of the information that is provided by the electronic warehouse receipt using another technology called blockchain that makes sure that everything that is stated is unchanged, remains unchanged. So at the end of this process, a country like, let's say, Guatemala or Mexico that wants to sell its agricultural products using an electronic warehouse receipt has the benefit of relying on information that these new types of technologies like the Internet of Things or something else called the smart contract that enables you to repossess very quickly without having to go to court. All that is put into the new electronic warehouse receipt and in a fashion that is described as bundled. You bundle the deposit of receipt information with the information concerning the quantity and the quality or the ability to recover the product. And whoever has that electronic record, as it is called, knows that there is no question. When we were trying to get the Mexican Warehousing Association to adopt an electronic warehouse receipt, we invited the lady at the Department of Agriculture in the United States that designed this procedure, both electronic and otherwise, and she was lecturing the Association of Mexican Warehouses. The first question that they asked her was, how many cases of fraud have you had with your electronic warehouse receipts in the last year? She raised her hand like this in a big zero, and she said, zero, none of them. Millions of transactions, no fraud. Okay, now this is something that technology can give you, but at the same time, when you use a technology, you have to use it in a way in which it is like we were taught by the German Civil and Commercial Code. You have to use it as an ordentlichen Kaufmann, as somebody who's really an honest and decent merchant would do. And because you could hide it otherwise, and you could try to trick it otherwise. So once people understand that trustworthiness in the international markets depend upon not only the legal requirements of good faith, but also the combination with the electronics of the new technology, then we have a much better world. Then these countries might not have to have as much poverty as they're suffering right now, because the rest of the world could trust their products.
Many thanks, Anna, for your very interesting question. And we have a little bit late with the schedule. So on behalf of Commercial Law Department and the Law School of University of Chile, I would like to thank Professor Kosolski for your conference and for share with us your thought, and also with the participant of the 12th Transnational Commercial Law Teaching Meeting and the public. I would like to also thank all of you, the attendants, for connecting to this conference. We hope to have soon a new opportunity to share with you a time to talk about commercial and transnational legal challenge and most development solutions. Many thanks.
Thank you.